Patents. A patent is a logically monopoly granted for a limited time to the owner of an invention granted by law. In many countries, an inventor of a new product or process can apply for a patent, giving the holder the exclusive right for a number of years to produce the good or use the process. This right can be used either through their own business or by changing a license fee. Without obtaining a license from the patent holder, the work cannot be used or reproduced. It is property right for an inventor granted by a government to the inventor. Utility patents protect inventions that are novel, non-obvious and useful. Under the TRIPS agreement of the WTO, inventions in all fields of technology, whether products or processes, are patentable if they meet the criteria of novelty, involve an inventive step and are capable of industrial application. Patents are one of the oldest forms of IP protection. The patent system started in the 1700s. The aim of the patent system is to encourage economic and technological development by rewarding intellectual creativity. There are three main types of patents. Utility patents. This is the patent of invention and is used for an invention of a new useful process, machine, manufacture or composition of matter. The duration of the utility patent is 20 years from the date of patent application and is subject to payment of maintenance fee. Design patent. It is issued for a new, original and ornamental design of an article. The duration of such type of patent is 14 years from the date of patent grant. Developments in science now permit the definition of specific genes and open the door to intellectual property rights related to living matter, giving rise to concerns about the exploitation of plant genetic resources. Plant patent. This type of patent applies to characteristic of a new plant that has been asexually produced. The duration of the plant patent is 20 years from the date of filing application of patent. Procedures for patent filing. An inventor must register his invention in each country where he wants the product to be protected. Depending on the IPR protection laws of that country, the inventor is denied or granted total or partial protection of his product or process for a number of years, after which the invention moves into the public domain and can be used by anyone. In patenting, the person who brings the original patentable item is called inventor. The person or entity who is filling the application is called applicant, and the legal representative who is filling patent on behalf of others and providing service to them is called the patent attorney or agent. Steps involved in patent filing are: conceptualization of idea. It includes inventing or contriving an idea or explanation and formulating it mentally. Documenting the invention. Prior art search. During this stage, the invention is checked in public domain whether the same form of patent is filed or granted or not. Detailed patent application drafting. Filling the patent application. Submission of an application for examination to the patenting authority. Maintenance of the patent once granted. There are two types of patent application. They are provisional patent specification and complete patent specification. In the former, at the time of filing, it needs to explain the invention in detail and have to file a complete patent within a year. If not filed within 1 year, a patent application becomes invalid. In the latter, it needs to explain the invention in detail along with direct application without a provisional one. Patenting organizations are World Intellectual Property Organization WIPO, Patent Cooperation Treaty PCT, Intellectual Property India under Government of India, etc. Patents and other rights. Patents seem to have occupied a secondary place while discussing the IPR related issues regarding Internet. In view of the transcontinental nature of the internet operation, it would be better to minimize infringements by providing better protection mechanisms through better technologies for encryption and decryption. In the context of e-commerce, these technologies play a very important role as they provide the best solution for avoiding unlawful access to what is being transacted on the internet between two or parties. This secrecy could only be maintained by assigning special keys or codes to the players of e-commerce having unique identification. The concept of digital signature is based on these technologies. The development of digital technology has permitted huge expansion in the capacity for encrypted services. However, at the same time, the sale of unauthorized decoding devices has had an adverse effect on the operators of encrypted services. E-commerce has estimated that unauthorized decoding devices currently represent between 5 and 20% of the total number of devices in circulation. This would promote some internet service providers and database operators to monopolize such devices and make the users dependent on the operators for many other facilities which the users themselves can arrange. Whereas in India, software is not patentable and these are considered literary works, in advanced countries it is now possible to obtain software patents. These are two advantages of software patents, namely copying of the idea of a patent is prohibited and a stronger legal protection is ensured. One of the reasons of starting software patents is that these are now developed with substantial investment of finances and human resources and are responsible for better functioning machines, novel performance of microprocessors, and when transported through disks, it becomes a tangible product.